Welcome to the second panel of today's Thorough Symposium. Thank you all for returning after lunch. We have a full afternoon still of things to learn, and I'm very excited about the opportunity and privilege of moderating this afternoon's panel. The subject of this second session is when federal judges and state and local politics collide. This is obviously a subject that has been much in the news of late, including in the context of same-sex marriage and immigration. It's an issue of beyond the sort of the headlines that has been percolating really for at least the last 10, 15 years, and that is coming to a head in lots of important ways at the moment. So we're lucky to have a group of very distinguished panelists to walk us through it and highlight some of the interesting questions that are on the table. We will proceed in the order in which the panelists are arrayed. I'll briefly introduce everyone at the outset so we get that out of the way and can proceed with our discussion. And we plan to have time at the end a bit for the panelists to engage with one another and then to take your questions. So please, as we go along, be thinking and be prepared to join the discussion. So Alison Zeeb will begin. Alison is the director of the Public Citizen Litigation Group and particularly directs its Supreme Court Assistance Project. She's litigated a number of the most significant Supreme Court cases in this area, and thus we wanted to lead off with her to sort of frame the discussion that will follow. She's also an adjunct professor at Georgetown Law School and is a member of the Administrative Conference of the United States. Kathy Sharkey is a professor of law at New York University Law School at NYU. She's written widely on federal preemption in the particular area of products liability, but has also written on punitive damages, on class actions, and other important relevant areas here. And most importantly for me, she was my law school classmate, so I'm especially glad to have her here with us. Doug DeJame will be next. Doug is an associate professor of law at Loyola Law School of Los Angeles. He writes on law and social movements, on cause lawyering and anti-discrimination law, with a particular emphasis on sexual orientation discrimination. And he'll be talking about some of these cases that again have been prominently in the news recently. And finally, my colleague Bill Busby will close the presentations. Bill is a professor of law here at Emory and directs both the Environmental Law Program and the Center on Federalism and Intersystemic Governance. He works with the Center for Progressive Reform and does regulatory work there. He's recently published with Cambridge University Press the book Preemption Choice: The Theory, Law, and Reality of Federalism's Core Question. So we have a great panel. I want to jump straight to it and give them all a chance to share their thoughts before we then again open it up for discussions and questions. So please, Alison.
Good afternoon. I'm a practitioner, not an academic, so I want to start by quoting Bruce Springsteen, as he said at the Academy Awards one day. He said, "Thank you for inviting me to your party." I'm very happy to be here. I expect that my comments will be maybe less profound than a lot of the other speakers that you'll hear today. My perspective on the issues that we're going to discuss is a practical one. My interest is in access to courts, giving people an avenue to pursue remedies for injuries that have been suffered, and the integrity of the civil justice system. With that in mind, I'm going to start by sharing with you my reaction to the topic that we were asked to talk about today, when federal judges and state and local politics collide. I don't generally see a collision between federal judges and state politics. That is to the extent that our topic heading suggests there's something amiss when federal judges rule in matters that implicate state law or state politics. I think that's fine. Section 1983 cases, for example, which provide a remedy for state action and state policies that violate the federal Constitution, seems to me a crucial tool for protecting fundamental rights. So the Prop 8 case in California, for example, which one of the panelists will be discussing in detail, doesn't raise a question about whether or not the federal court should be mucking around in a state's decision with respect to same-sex marriage. The federal courts are the proper place to raise that constitutional challenge. And what we're seeing in cases like that is not a new collision between federal courts and state politics, but just the back and forth that's inherent in a federalist system. But I think I was asked to speak to you today because of my particular interest and work on cases that involve the question of federal preemption of state common law. These are cases in which a consumer who's been injured by a drug or a medical device or an automobile or a pesticide files a suit against the product's manufacturer under state common law alleging failure to warn or product defect, manufacturing defect. And the manufacturer in response argues that the case is preempted because the state common law claim conflicts with or frustrates or poses an obstacle to the accomplishment of the federal regulatory scheme. The theory of implied conflict preemption raises much more difficult issues about federal-state relationships than 1983 cases, for example. Unlike the Chamber of Commerce's challenge to Arizona's immigration law, a case the Supreme Court heard a couple months ago, in tort cases, the preemption theory is not that Congress made a conscious decision to oust state law. The theory is much more nebulous, and so the potential for improperly ousting state law and cutting off individuals' access to courts and to any possibility of a remedy is much greater. So to back up, and because I'm in a law school, I'm going to offer a brief primer on first-year tort law. Traditional state tort law and the current law in most states allows a manufacturer who is alleged to have sold a defective product to present evidence in its defense that the product complied with applicable federal regulatory standards. And that evidence of compliance is used as, in most cases, non-dispositive evidence that the manufacturer acted non-negligently. So in this way, traditional tort law principles recognize that federal product approval and compliance with federal regulation has a role to play, and potentially a very powerful role, in product liability cases. A typical jury instruction might say, for example, that FDA approval, though not dispositive, may be considered to show whether a product is unreasonably safe. In some states, the evidence of regulatory compliance raises a very strong presumption of non-negligence. In some cases, it's just evidence the jury can consider. Over the past 20 years or so, manufacturers have argued that regulatory approval or compliance with regulatory standards is not just a defense on the merits, not just evidence that the product was not defective or that a label was adequate, but a defense to being sued at all. The notion is that if a manufacturer is subject to federal regulation and complied with applicable regulations, then holding it accountable for harm caused by its product would frustrate the federal scheme. Too often, in my view, judges are open to these arguments and hold that state law damages claims cannot go forward. Do these cases show a collision between federal judges and state politics or state policies? Well, after all, the states have decided to provide a cause of action, a means to seek a remedy, but federal law is being used to thwart that state decision. Well, to begin with, if there's a collision, it's not only one between federal judges and state law, but federal and state judges on the one hand and state law on the other, because many of these cases are litigated in state court, and the implied conflict preemption theory has the same result for the litigants and for potential future litigants, whether the decision comes from the state court or the federal court. But putting that aside, I think that the cases in which courts have found that common law is preempted because it would frustrate some federal regulation manifest primarily, if not a collision, a lack of appreciation for state law remedial schemes. From a practitioner's perspective, the conflict preemption cases don't reflect a principled application of federal law to review state law claims because they're not based on principle. Rather, they seem to me to be cases in which a judge is himself or herself applying that traditional regulatory compliance defense and deciding that a reasonable manufacturer had done enough to satisfy any obligations owed to its customers, and calling that application of the traditional regulatory compliance defense typically left to a jury, calling that preemption. Put another way, the question in a product liability case in which a manufacturer complied with a regulatory scheme is, would a reasonable manufacturer have done more? Did the manufacturer owe a duty to the customers to do something more? A holding that federal regulation preempts a court or a jury from even asking this question is in essence a holding that the answer is no, a reasonable manufacturer would not have done more. And to answer that question through a finding of preemption is to turn a question of fact under state law into a question of federal law. And that result illustrates an unfortunate and inappropriate collision between state law remedies and federal court decisions. On the other hand, these cases are often litigated in federal court because the cases are brought in or removed to federal court based on diversity of citizenship. And when the parties raise them, the federal courts cannot avoid ruling on issues that affect and potentially oust state law. As in the 1983 cases, my concern is not that federal courts address these issues. My concern is with the use of malleable legal doctrines to displace state laws that Congress has not chosen to displace. 30 years ago, 20 years ago, for a defendant to argue implied conflict preemption in a tort case was extremely rare. Today, a motion to dismiss based on preemption it's more than commonplace, it's expected. A few things are responsible for this development. First, today, judges and the public and legislatures are much more wary of lawsuits, much more distrustful of the jury system than they used to be. Articles, reports, and a very effective public relations effort have convinced us that there's a proliferation of frivolous lawsuits that harms business and the economy. A few years ago, I accompanied a gentleman testifying before a House of Representatives hearing on preemption. He had brought a case against a drug manufacturer because the packaging and labeling of the bottle had, he alleged, almost resulted in the death of his newborn twins. But during his testimony, he felt the need several times to emphasize that he was against frivolous lawsuits, because although he had a lawsuit, and I didn't think it was a frivolous one, he still had the view that most lawsuits were frivolous and that this was a problem. I think that lots of people think that. Is it true? Studies show it's probably not. But the point is, in a society where people have lost respect for juries and for the right to seek a remedy, the courts are more open to the idea that a common law claim is an interference with federal regulation. The other development that pushed along implied preemption over this decade is that from 2001 to 2008, the White House was very skeptical of common law suits and more protective of business interests than previously, and the government encouraged defendants and courts to find implied preemption in a broad array of situations. Without government support, it's much harder for these claims of implied preemption to succeed. My point isn't to criticize the administration. I mention it to show that obstacle preemption is very susceptible to manipulation, because the answer to the legal question, whether a state common law claim poses an obstacle to the accomplishment of a federal objective, can turn on the federal politics of the day. State tort law is largely judge-made law, and in this way, preemption shows not so much a potential conflict between federal courts and state politics, but between federal politics and state courts. In fact, if you read the decisions, you'll find that the elements and purposes and operation of state law in preemption cases is barely discussed. So to finish, I just want to go back to where I began. My interest is in access to courts, preemption, enforcement of forced arbitration clauses in consumer contracts, limitations on standing, barriers to presentation of experts, the Iqbal-Twombly line of cases on notice pleading. All of these are barriers to access imposed by the federal courts, barriers that limit people's ability to use the civil justice system, a system that is dependent largely on state law. And the collision between the federal courts, what I see as the anti-litigation bias, and the traditional role of state law as the primary source of redress for individuals seems to me a dangerous collision, to come back to that word, that threatens not only people's ability to redress grievances, but the role of the court system as a deterrent to wrongdoing and as an impetus to innovation. Thank you.
Thank you very much. I very much appreciate the invitation to speak here and also the warm hospitality, including the pickup and drive from the airport, although without naming his name because I don't want to embarrass him. My driver, upon picking me up, said, you know, we're expecting snow. We'll probably have the symposium canceled and you'll be stuck here for a few days. That wasn't a correct prediction, given how we've been treated. That might not have been the worst. But in all seriousness, I'm really excited to take part in this very rich event. And the icing on the cake, of course, is seeing my old law school classmate, Bobby, and it reminds me to tell all the law students here, you know, be nice to your law school classmates, because when they're in powerful places like now Associate Dean Adier, it might help you out down the road. I'm going to speak to you today about what I want to call judicially managed federalism, and the subtitle, what I'm going to focus mostly on, is called States Push Back. So very briefly, the reason I want to call this judicially managed federalism is a lot of times when we think about big debates in federalism, or as has been conjured earlier, the big looming debate over the constitutionality of the individual mandate in healthcare, et cetera, we're thinking about Congress and Congress's power, right, to enact federal legislation, and we're thinking about the court chipping back on that kind of power, regulating that authority. Instead, in the contrast I want to draw here, I'm talking about judicially managed federalism. I'm going to talk about two areas of the law, punitive damages and federal preemption of state law. Allison's helped me a lot by giving you the background on preemption, which should help me keep to my limited remarks here. And these are two areas that I think are really important federalism areas, but they're not often studied as such, and it's not often brought to the fore that these are areas in which judges, whether they're state or federal court judges, are affecting the allocation of power and authority between the states and the federal government. So I think it's a really important and rich area and fits within the conference theme here. So punitive damages, and actually one other thing that I like when I'm talking to both law students, groups of law students and practitioners, and these, by the way, in addition to judges, are my favorite audiences brought together, because punitive damages and federal preemption, as a lot of the practitioners and as Allison echoed, is enormously important in actual litigation in the real world, particularly in products liability disputes. And they're two areas that sometimes kind of fall through the cracks in how we teach in law school, right? Sometimes you encounter punitive damages. If you take it from me, you can encounter both of these subjects in torts, but a lot of times it falls through there. You might get some of it in constitutional law, maybe federal courts, maybe administrative law. The great thing about these topics is that they take from all of these different areas. So punitive damages, the interplay that I want to speak about is the U.S. Supreme Court has created a constitutional edifice, so federal law overlay on reviewing excessive punitive damages awards. And in general, the reason that this becomes sort of interesting, they're doing this under the Due Process Clause. There's both substantive due process and procedural due process. The court has invoked both as rationales for reining in punitive damages, but punitive damages otherwise is within the purview of state law, particularly state tort law, and state substantive and procedural law can clash or come into conflict with this federal overlay. So that's why punitive damages is going to be interesting to me. Federal preemption, and Allison gave you a very good primer here. As she mentioned, what's really interesting thinking about this clash is state tort law does have what's known as the regulatory compliance defense. And in every single state save one, so Michigan here is an outlier, in every state This is either some evidence of non-negligence if you've complied with the federal regulatory standard, or it might be a presumption, or it might be a rebuttable presumption. Only in Michigan do you get absolute immunity, whereas federal preemption is very much a blunter form of that. So if you can raise a federal preemption defense, you raise it at the outset of your case, and it's going to mean that the defendant is out of the lawsuit. You can't bring any of your state tort claims, or the ones that are preempted, forward. So it's also interesting to me to think about the clash that arises under this area. Now, there are noticeable differences. So note, in punitive damages, we're talking about the U.S. Supreme Court that kind of created this due process-inflected federal excessiveness review over the awards. In federal preemption, we're looking, at least we say, courts say we're looking in the first instance at Congress, and they are. They're looking at Congress that has passed legislation. What's quite interesting is we have no national products liability law, right? Congress could create national products liability law and tell us what standards should be enforced for product defects, et cetera. We don't have that, right? We have state-by-state tort paradigms here. However, Congress enacts piecemeal legislation. So we have, say, the Food, Drug, and Cosmetic Act. We have the Motor Vehicle Safety Act. So we have Congress enacting piecemeal legislation that will regulate automobile safety or food, drugs, medical devices that were also being regulated by state tort law. Now, the interesting thing is Congress also, if it wanted to, could be very clear, right? With the stroke of the pen, Congress could say, we are setting up this standard and it will displace the state common law. But Congress doesn't do that. And I've studied this pretty extensively, and we could debate, if anyone's interested, whether it makes sense at this point to keep exhorting to Congress, please be clear, put all our faith in Congress. My own views differ, but that's beside the point for the clash that I want to talk about here that comes up. So let's start with punitive damages. I want to talk about a single case, just to use as an exemplar, which is called Philip Morris versus Williams. You may have encountered this case. It's the third in a kind of trilogy of U.S. Supreme Court cases where the U.S. Supreme Court has created this constitutional edifice looking over punitive damages awards. So very briefly, in the earlier cases, BMW versus Gore and State Farm versus Campbell, the court set up what it calls 3 guideposts. And these guideposts have become very important to lower courts of what to do when they get very large punitive damages awards. The first one's reprehensibility. The second one's a ratio. Technically, it was supposed to be the ratio of the punitive damages to the harm, but compensatory damages have become the proxy for the harm. And the ratio, punitive to compensatory ratio, is actually something concrete lower courts have been able to fixate on. And the court has said cryptic things over the year, like we're not imposing a bright mathematical formula, but, read between the lines, single-digit ratios are more likely to comport with due process, right? So they've signaled to lower courts what they're thinking in that realm. And then the third has been looking to comparable sanctions, statutory or criminal sanctions. So in Williams, what happened is the jury, this was a wrongful death suit. The widow of someone who got lung cancer and was deceased brought a deceit action against Philip Morris, saying that they had misrepresented, they had done fraud and misrepresentation of the dangers of cigarettes, and the jury awarded around $820,000 in compensatory damages and, right, you're always waiting for the and when it comes to the punitive damages award, $79.5 million. Okay, so it's not billions, but it's $79.5 million, and it's roughly a 100-to-1 ratio, right? So anything these days above the single digit, you have to do some work if you're a lower court, and you want that to be to withstand appeal. So what happens here? It's kind of an interesting story that I'll have to tell in brief notes, but it's a back and forth between the Oregon. This happens in Oregon, so between the Oregon State appellate courts and the U.S. Supreme Court. The back and forth lasts about a decade. So for anyone paying attention, if you compare it to, say, Exxon Valdez, well, that was 2 decades. So 1 decade, maybe that doesn't seem so long, but that's a long time to be waiting to hear the fate of your jury award in a single case. And it involved 3 certiorari grants by the U.S. Supreme Court, right? So the U.S. Supreme Court got to hear this case on 3 different occasions, or actually the first course, they just remanded after State Farm versus Campbell, right? After State Farm versus Campbell, where they said single digits look good to us. Here, Oregon Appellate Court, do something with this. And what happened? So what happened is the first time that it gets remanded to the Oregon Appellate Court, they reinstate the award in full. I didn't tell you one fact that's kind of interesting, which is that the trial judge originally cut the award to about $32 million. But the Oregon Appellate Court looked at the facts, thought it was very reprehensible, also thought that Philip Morris had a lot of wealth, and that came into its decision, and they reinstated the award in full. Once the U.S. Supreme Court slapped them down and said, please look this over after State Farm, they nonetheless upheld their verdict again. And then it gets to the Oregon State Supreme Court, and the Oregon State Supreme Court likewise affirms, saying that there were all sorts of reasons, even after State Farm versus Campbell, if you look at the reprehensibility of the action here, that the award should be sustained. So at that point, the award goes back up to the U.S. Supreme Court, and now the legal issue, what's sort of interesting is it goes back up, Philip Morris tries to get the court to look at two different questions. One is just substantive due process. This award, 100-1, is just too big, and the other is more procedural. And the procedural question is the one that the U.S. Supreme Court takes up. The procedural question was whether or not you can look to harm to others other than the plaintiff. So here there'd been evidence introduced to all of the fraud perpetrated on all, I might get this term wrong, Oregonians. I don't know if anyone sort of, that's the term for people from Oregon, all Oregonians who had been defrauded, et cetera. And so the court takes that question up, doesn't take the substantive due process, and says, in essence, that where there's a risk that the state appellate court process has not sufficiently satisfied us, and they're not too clear exactly what you have to do, that harm to others was not the basis of the punishment, then that's going to violate constitutional procedural due process. So they then send it back to the Oregon State Supreme Court. Now, what's really interesting at this moment is that people were looking at this a little bit like they'd looked at the previous U.S. Supreme Court back and forth in State Farm versus Campbell. This happened in Utah, and when the Supreme Court returned it back to the Utah State Supreme Court, they said in State Farm, you know what, in this case, the compensatory damages look large enough. 1-to-1 looks good to us. What do you guys and gals think? And they come back with a 9-to-1 ratio. So I think most people thought that's what would happen in Oregon. Instead, right, in the kind of move of what some people have called thumbing the nose at the court, others have called just sort of bold protection of state law interests, the Oregon State Supreme Court reinstates the full award, and they do so on what they say is an adequate and independent state law ground. So here they say there was a jury instructional error issue, and it's not that important for us to go into the technicalities of this, but the basic idea was that Philip Morris had not objected to the actual instruction given, had just proposed an instruction. There's actually an important lesson for people who are going to be litigants to make sure you cover all your bases when you're objecting to instructions. But as a result, Philip Morris was relying only on their proposed instruction, and their proposed instruction was not, quote unquote, correct in all respects. And the court pointed to some places, for example, in their instruction, they said that the court may look at these kinds of factors when it should have been shall look at those factors, things like that. Well, what was interesting to people is this was something that the plaintiffs had raised at all stages of the litigation. There had been something like, numerous, at least 6 different opportunities for the courts to have entertained these arguments. They didn't. They waited until after the U.S. Supreme Court had sent the case back on a constitutional issue, telling the court to look at it again, and then they invoked this adequate and independent state law grounds. So what's interesting to me is there are at least, I think, 2 morals of the story. I didn't finish the story. Let me finish the story. So then Philip Morris petitions the court again, right, asks for cert. The U.S. Supreme Court takes the case, takes the Williams case again. People are thinking to slap them down, maybe to deal with the substantive due process issue at long last. And the court listens to oral argument and then digs the case. That means dismiss as improvidently granted. So we don't know why when the court decides to do that, but the Oregon State Supreme Court seems to prevail, right? The court doesn't go on a kind of substantive due process, doesn't pick up that question, and says the procedural question that it had taken again, it wasn't going to decide. So to my mind, there are 2 morals, right? There are 2 morals, quick morals in this story. One are that there's some powerful limits to the way in which the U.S. Supreme Court is going to be able to control this realm of punitive damages. Importantly, and this gets into some of the legal doctrinal reasons, importantly because the court has actually shifted from a substantive due process review of awards that are just too big to a procedural due process one. And when they move to procedural due process, state courts are going to have more leeway room for coming up with different kinds of procedural type defaults. There are all sorts of other ways in which the U.S. Supreme Court is going to be limited here, unlike, say, habeas review, which we heard a little bit about earlier, about the gall or the defiance of a single federal judge being able to overturn what had been looked at in the state courts. Unlike habeas, which at least goes to the lower, federal courts and then all the way up, here we have the U.S. Supreme Court trying to police the highest decisions of the state court. So it's going to be limited in terms of its docket, et cetera. The second moral of the story, though, that I think is sort of the more provocative is, will the Oregon State Supreme Court here be a kind of model of state defiance, right? And they get away with it, right? People have said things like, the U.S. Supreme Court blinked at the end in this showdown, right, with the Oregon State Supreme Court. And there are, of course, all sorts of ways that states could be galvanized, both state legislatures and state courts, to try to either thumb their nose or stand up, push back against the U.S. Supreme Court. So one would be finding procedural default rules like this. Others would just be to say, well, maybe reprehensibility can be so great, that factor, that it will trump the ratio factor. Some courts are trying that presently as we speak. Another avenue would be to look at defendants' wealth. Thus far, the U.S. Supreme Court has been very cryptic about what you can do with defendants' wealth. They say defendants' wealth can't justify an otherwise unconstitutional award. That doesn't really tell you very much about whether or not it's right, as many states like California, New York, others do, ask jurors to explicitly take the wealth into account. So I think it's kind of interesting to think about in that kind of framework. Now, I on purpose extended my remarks on punitive damages to only make a very brief mention, right, very brief, since I have 3 minutes remaining. No, I'll be fair. My time is up, and But Bobby, this is where we get back to, be nice to your law school classmates. This is one of those moments. But let me just say very briefly, just a few remarks about federal preemption, mostly just to maybe set up a little bit of a interchange, or a provocative one with Allison, because to my mind, and I was thinking about this actually when Charles Fried, one of the reasons I want to extend my time is because I want to mention something that Charles Fried said that really resonated with me. He was talking about statutory interpretation and the Scalia versus Breyer debate, and he talked about the idea that there's a meta game. And I have to confess, I always thought that anything you can do better, I can do meta, was just a mockery of Yale Law School professors. At least that's how it was told to me. So I need to learn more about the derivation of that. But the meta game that's never set down, I think, is actually a really good way to think about these preemption cases, because to my mind, when you read through, and I've done a lot of work in this area, when you read what the courts are saying, and they say the touchstone of our decisions is congressional intent, and the words of the statute are what matters, and we read those words and parse them, it doesn't explain the decisions. And my own view is the metagame, what's going on in these cases, has a lot to do with the underlying federal agency. So just in brief, in these cases that are about the drug or medical devices or Motor Vehicle Safety Act, what FDA or what NHTSA, for example, is doing, not just what they're saying, what they're doing in terms of analyzing risk analysis in the regulatory record, unbelievably influential in these cases. And for my purposes, why it's interesting in this clash between the feds and states is that if you look, and I looked at this in a narrow realm of FDA preemption cases, pharmaceutical cases, there are seemingly discernible differences between state and federal courts. It's something that Lee Epstein and the other empiricists I would love to do on a broader level, because these are just me in the Freudian way, reading through cases, looking at the arguments, looking at them, but probably I looked at maybe 30, 40 of these kinds of cases, and federal courts I'm going to paint with a broad brush. Federal courts here are much more likely to care about what the federal agency has to say, what the FDA says. They're more likely to ask for the views of the federal agency. The federal agency is more likely to submit on its own its views to the agency versus the state courts. State court opinions are more likely to have things where the state court says, we don't, I mean, I'm paraphrasing, we don't care what the FDA would say here. We have our own state law that's governing this issue. And to my mind, I think this is a problem that merits attention because we have state and federal courts that are interpreting the same federal statute and they're using a different paradigm, right? They have the metagame, right? The how much deference should we give to the view of the underlying agency? What kind of empirical evidence should we require in the regulatory record is nowhere in their actual framework, but I think it's actually explaining these decisions, and I don't think it's a good thing that we have these two different ways of looking at the same issue. So thank you for your indulgence, and I will now sit.
So I want to thank Bobby, a DA, for actually organizing our panel and for inviting me here in the first place. I also wanted to thank Eric Muir, the law review staff, especially Rachel Mondel and Eugene Cornell for organizing a really fantastic symposium, and my driver, Ben Seidman, who I can acknowledge because he didn't say anything mildly embarrassing, who gave up his night to actually bring me to the hotel. So I was asked to speak about Perry versus Schwarzenegger, the federal litigation challenging Proposition 8, which is a California state constitutional amendment, and the challenges under the federal constitution. So as you can probably tell, this isn't exactly in line with what some of my co-panelists are talking about. I will not utter the word preemption. In some ways, this is like a commercial break, but hopefully we can figure out some of the common themes, and I know Allison tried to set me up a little bit for that in the Q&A. So instead of understanding the district court decision as a federal judge intervening in a state issue of same-sex marriage, I propose that we view the decision from the perspective of the LGBT rights movement to understand how we arrived at the point where a federal judge is invalidating a state prohibition on marriage for same-sex couples. So on the one hand, Judge Walker in the district court was weighing in on an issue of national significance. California's situation has become emblematic of a broader national debate. The federal courts are now participating, weighing in just like other governmental branches. They're commenting on similar constitutional norms to those that state courts have commented on, and they're responding to state political developments. But on the other hand, Judge Walker ruled in a marriage case delivered to him against the advice of LGBT rights movement advocates. Precisely because movement advocates are sensitive to the relationship of federal courts to state laws and the broader distinctions between law, politics, and culture, movement lawyers, those at Lambda Legal, the ACLU, the National Center for Lesbian Rights, and gay and lesbian advocates and defenders, have sought to keep the federal courts away from Prop 8 and other marriage amendments. Indeed, the framing of this panel, when federal judges and local and state politics collide, suggests why movement advocates are reluctant to present marriage equality as a national federal issue right now. And not only are they worried that the Supreme Court will render a negative decision, but they understand the political messaging that accompanies a federal judge intervening in state politics and invalidating potentially the laws of several states. Yet a challenge from a new movement organization purporting to represent the movement with new elite allied support pressed the issue in the federal courts. Movement lawyers' sophisticated view of litigation, which understands the political possibilities and limitations of court-based strategies, I would argue contrasts sharply with the single-issue, institutionalized reliance on litigation by the movement challengers, the American Foundation for Equal Rights, or AFER, who seem to have been seduced by the lure of litigation, what Gerald Rosenberg would call it. This well-resourced challenge to conventional movement wisdom materialized precisely because movement advocates had achieved so much success in using a legal mobilization strategy. That is, a strategy that uses litigation in conjunction with a range of other tactics for its mobilizing and political potential has helped to place marriage equality on the national agenda. And I want to suggest today that understanding the Prop 8 federal litigation through the lens of social movements exposes a tension in legal mobilization that movement advocates themselves must confront. The same strategy that yields movement progress may create the conditions that allow a viable challenge to movement strategy. And this is what I call the legal mobilization dilemma. Successful legal mobilization mainstreams movement goals and may create the conditions that allow threats to movement progress coming from forces inside or allied with the movement itself. And movement advocates must then respond and try to mediate these challenges in an attempt to preserve what they deem their best strategy. So in many respects, the LGBT rights movement, including its push for marriage equality, has been tremendously successful, and litigation's been a big driver of this success. The first comprehensive relationship recognition regime, the first state to offer marriage to same-sex couples, came through state court decisions, and litigation has basically helped to mainstream gay rights and gay equality norms. Indeed, I think the fact that civil unions and domestic partnership have become moderate compromise positions owe much to the fact that litigation pushed for marriage. It's easy to see the federal court decision in Perry as part of this narrative of successful litigation, but I'm telling a different story of Perry that situates it as an example of a challenge to movement strategy. So successful legal mobilization has produced what I argue are important effects that facilitated this challenge to movement strategy. First, litigation helped raise consciousness among constituents and increase their sense of outrage. The battles over marriage equality, especially that in California, increased the salience of the issue. The fact that couples in California were able to marry and later have the right eliminated, I think only increased the sense of deprivation. And the Prop 8 aftermath really saw a lot of mobilization around marriage equality around the country. And while there was a lot of outrage directed at the movement advocates over their political messaging, the advocates, for their part, urged movement constituents not to file federal litigation challenging Prop 8. Mainstreaming of the social movement norm, secondly, produced a narrowing effect on both tactics and issues. So as marriage equality gained priority among constituents and organizations and in national political conversations, a more favorable environment was created for a single issue, formalized organization. So how did AFAIR come about? Chad Griffin, a gay political consultant and strategist in LA, approached movement leadership about a federal suit challenging Prop 8. Those organizations refused to take the challenge, and Griffin moved forward with AFAIR, of which he's president and co-founder, and wealthy, connected gays and lesbians began to formally organize around marriage equality outside of mainstream movement channels. The movement organization has a single issue orientation. It's right now capitalizing on mainstreaming of gay equality norms to frame the goal of same-sex marriage as universal and general. It relies on a liberal and conservative coordination. The chairman of the Libertarian Cato Institute is a co-chair, along with the president of the Center for American Progress, of the advisory board to AFAIR. This universalizing and here conservatizing trend is even evidenced in the organization's name, the American Foundation for Equal Rights. I would argue tells us nothing about the constituents and the cause, and is quite generic. They proclaim the American Foundation for Equal Rights is dedicated to protecting and advancing equal rights for every American, even though right now they're only pursuing marriage equality. It's a highly professionalized organization with a board of directors, an advisory board, a communications director, a development director, and it's relying exclusively on institutionalized tactics, namely litigation right now. Perhaps the movement's successful use of litigation has channeled movement advocacy and challenges even more into litigation. Third, successful legal mobilization increased the salience of the marriage equality issue and convinced elites to support the cause. Elite support has allowed constituents to find new resources, especially financial resources, with which to organize around. And elites tend to support organizations that are professionalized and that rely on institutional tactics. So the cultural and political elite are big supporters of AFER. The board members include Rob and Michelle Reiner. There have been fancy, expensive benefits, one in New York, co-sponsored by prominent Republicans, Ken Mellman, Bill Wells, Christine Todd Whitman. A recent event that they did in Beverly Hills had an Elton John concert that raised $3 million, right? Not something that normal movement organizations can put together. They bring the prestige and fame of the legal elite with the legal team of David Boyce and Ted Olson and their big firm resources, and again, a liberal and conservative pairing. And while the consistent theme of liberal and conservative coordination highlights the strategic attempt to depoliticize the issue of marriage equality, it also suggests a quite limited range of goals and tactics that the organization can pursue with this leadership, representation, and donor base, right? Where does an organization like this go after same-sex marriage? Finally, successful legal mobilization has produced a more open and favorable political opportunity structure. Specifically, the new movement organization has seized on the increasing number of state actors, including state political officials and federal judges, sympathetic to the social movement claim, and they've asked these actors to move forward the central goal of marriage equality. So there's a more favorable elite alignment in California. The Attorney General at the time of the litigation, Jerry Brown, now Kamala Harris, the governor, then Schwarzenegger, now Jerry Brown, have all come on board to the marriage equality campaign. The same state officials that opposed marriage equality in the state court litigation came on board in the subsequent state court litigation challenging Prop 8, arguing that the original Supreme Court decision from the California Supreme Court convinced them. And so then it's unsurprising to see them not defend Prop 8 in federal court. We've also seen a more hospitable federal judiciary, and I would say that's more because of the mainstream of gay equality norms than because of a more liberal judiciary. Indeed, we have Republican appointees striking down laws like DOMA and Prop 8. There's a potentially sympathetic Supreme Court based on successful litigation around Romer and Lawrence that evidences Justice Kennedy's potential commitment to sexual orientation equality. There's sympathetic federal judges like Judge Walker and Reinhart who aren't, as Professor Fried considered this morning, neutral umpires calling balls and strikes, but rather elite institutional allies. The anti-same-sex marriage forces made much of Judge Walker's sexual orientation, arguing that advocates had found a gay judge to decide their claim, and they sought to disqualify Judge Reinhart based on his wife, Ramona Ribston's position on same-sex marriage and Prop 8 while head of the ACLU of Southern California, which submitted an amicus brief at the district court. Judge Reinhart didn't recuse himself. He noted that he normally would when the ACLU of Southern California files an amicus brief at the Ninth Circuit. Interestingly, the ACLU of Southern California did not file a Ninth Circuit brief, instead leaving that to the institutionally separate ACLU of Northern California and ACLU LGBT Rights Project. The experiences with both Judges Walker and Reinhart suggest that movement and counter-movement forces see judges as impartial, not as impartial outsiders, but rather, at a minimum, as part of a dynamic political opportunity structure in which they function as sympathetic or hostile elites. Or perhaps they're more than that, insider social movement activists embedded in the state. So I just want to finish up by pointing out how movement advocates have responded to this. What do they do, and where does their movement go from here? In some ways, the response requires a more nuanced approach than just traditional advocacy because they want to make clear their substantive commitment to the movement challengers' goals and yet preserve their strategy that they think is the most thoughtful. And so they've had to deal with the AFER strategy, which has put tremendous faith in courts. Beyond the fact that AFER would file such a high-risk case and urge the Supreme Court to invalidate the laws of a majority of states, the litigation team along the way has shown, at minimum, an insensitivity and lack of appreciation for the important extra-legal benefits of litigation. They resisted Judge Walker's call for a trial, instead pushing a preliminary injunction. And rather than follow Judge Walker's and now Judge Reinhart's attempt to really narrow the issue on California specifics, Ted Olson continues to talk about a fundamental right to marry and the suspect class status for sexual orientation classifications. LGBT rights advocates, on the other hand, understand tactics and arenas as frames. And so they've responded by trying to reframe the litigation based on this sensitivity. In their amicus capacity after an unsuccessful intervention attempt, they've argued that the case can be limited to California specifics, where there's a comprehensive domestic partnership regime, where there was a right to marry that was exercised and then eliminated, and that the distinction between marriage and domestic partnership seems like nothing other than an attempt to single out an unfavorable group, unpopular group for unfavorable treatment, which sounds like Romer, and so you need only apply Romer rational basis review and not approach fundamental rights or suspect classifications. And by asking the court to rule in this way, they're seeking to get a better chance of a positive Supreme Court decision or have the Supreme Court resist review, and at the same time limit the damage of a negative decision. They've attempted to negotiate the tenuous relationship between state and national politics, between court-centered and legislative reform. Again, the framing of this panel on the collision between federal judges and state and local politics suggests the resonance of these tensions. Lawyers for the LGBT rights movement groups understand that the public and elites are watching, and they're actively trying to mitigate the damage that could be done both by a negative decision and, importantly, by a positive decision in which federal judges hold invalid the laws of a majority of states. Thank you.
Good afternoon, everybody. I hope everyone's doing okay and staying awake. Nothing like being the fourth panelist in the after-lunch session. So those of you who are asleep, I'll try to speak quietly. And those who will be asleep, I'll try to wake you up. But so first, I'd like to be nice to your classmates, but more importantly, let's just all be nice. And then I'd like to also extend my thanks. Eric Meir and Rachel Mondel did a terrific job in setting this up, and Judge Hull and the Thrower family really helped us shape the planning for this whole session, and the Thrower family supporting the symposium yet again has just been a tremendous service to the legal community in Atlanta at Emory, and so personally I want to thank all those people. Also, the panelists who showed up for this session today are phenomenal, and we're very fortunate, so I really thank the panelists, especially my panelists here. What I want to talk about is a return to issues of clashing between federal courts and state law, and what I want to address is to talk what I call preemptions architecture. And in particular, I want to focus a little bit on the norms, policies, and instrumental aims that we see at play in preemption battles. But I want to step back for a second. I think today's sessions, we've talked a lot about courts, and I just think it's important to remember that when you're thinking about preemption issues, preemption battles, this is not just a judicial question, but one that is a realm of battle that occurs in Congress, it occurs before agencies, it occurs before courts, and it's also strategically used by litigants and private stakeholders and not-for-profits in all of those venues. And I think those who study preemption, observe basically all these institutional actors strategically anticipating each other and trying to shift their arguments in light of the most favorable venues they can use. So, for example, during the Bush administration, agencies were viewed as likely to be pro-preemption, and industry directed their fire to get favorable regulatory rulings or amicus briefs from federal agencies, and now you see that shifting today with a different administration. But to illustrate these issues of preemptions architecture and the norms, policies, and instrumental aims, here's the way I'll handle it. One is I'll make a very quick drive-by discussion of 3 recent major preemption cases. These are all product cases. These are the Bates case, Regal, and Wyeth. These are all cases from 2005, 2008, 2009. But just to understand for those who are not right now immersed in preemption, this is an issue that's critical to immigration policy, immigration battles. In the legislative arena, it's been a critical question. On climate legislation, it is now a big battle about the extent of common law and federal common law litigation about greenhouse gas emissions. So the whole realm of preemption is not just about courts, not just about products, but nevertheless, I'm going to focus on a few products cases too, because I think they're illustrative. I think what you see in these cases, as I'll illustrate, is fundamentally clashing views on the court about what are good policy and instrumental aims, with very different sort of techniques demonstrated by what I'll call the pro and anti-preemption blocks on the Supreme Court. And then I'll close briefly with 2 reflections. One about, can we make arguments about the legitimacy of these different approaches of these blocks to preemption questions, and then also just point out a few kind of preemption aims and variables that I think are sort of impoverished in discourse in the judicial arena. So my quick drive-by of 3 cases. The Bates case, 2005. This is an opinion by Justice Stevens involving issues of preemption of pesticide harm claims under FIFRA. And this case involved language about, the key word was requirements. And the court, in the opinion by Justice Stevens, very resoundingly rejected preemption arguments. The court said, what do we make of common law claims when a pesticide has been approved for a certain use? And the court said, an occurrence that merely motivates an optional decision does not qualify as a requirement. Very strong direct language. The court also stated this presumption against preemption, and that was stated, and that helped tip the scale. And then there was also in the case a fair bit of attention to history, in particular saying, in an era of tort reform battles, the likelihood Congress would mean to knock out common law claims and say nothing about common law claims is improbable. And then lastly, the court kind of quoted some of the standard literature about the good incentives created by the tort system, incentives for diligence and innovation and kind of ongoing addressing of risks. In the case, the court explicitly rejected arguments that these were their own paraphrases, what they called as crazy quilt approaches. So, you don't like crazy quilts. What's wrong with crazy quilts? I mean, I would never mind. Okay, so, and then in addition, there was a discussion where the court said that the court disagreed that there was a problem with 50 different common law standards, and then also the court dismissed arguments that juries might be inconsistent. So Bates, just to kind of recap, so it said requirements does not knock out common law. Common law incentives are good. There's a presumption against preemption, and motivating improvement is not the same as a requirement. Flash forward, 2008, the Regal case, again dealing with product risks, but this time dealing with medical devices and a different statute. So I should say, in the preemption law area, one of the standard lines is that preemption is driven by statutory language. It's a question of congressional intent. And so different laws obviously can lead to different outcomes if there are different language choices. But let's see what happens. So miraculously, this case also involved the word requirements. Okay? But this time, I should also say, there was no language about common law risks, no express addressing of common law risks, and as in, and there was also a savings clause, though the one that's a little funny where it was placed. And so it seems a lot like Bates, right? You have requirements, no addressing of common law risks, but this time the court says requirements, not only in this case, but basically in general, will apply to all statutes, and that the inducements created by common law are tantamount to requirements and will presumptively be preempted. Now, obviously, that overreaching is dicta that won't really bind future courts, but it's clearly a fairly expansive change in the word. What about Bates? When we were talking earlier about activism and restraint, so you would think, obviously the court's going to have to go extensively into the Bates case and distinguish it. Well, the Bates case was cited as reaching a pro-preemption outcome, which is true in one paragraph at the end of about 10 pages of anti-preemption discussion, but there's no distinguishing of the cases, no grappling with the different language. The two cases just stand there. Now, how did the court get there? The court said a contrary answer would make little sense, okay, and that the court even said that inducing greater safety would disrupt the federal scheme no less than state regulatory law. Again, if you remember, juries were applauded in the Bates case for the incentives, for diligence and the rest. Regal, interestingly, said that juries are a problem, that juries will be unlikely to see the benefits of a product, they will only see the risks, and there was a problem with 50 states taking their own approaches. He forgot crazy quilts, but I think he doesn't like them either. Okay, Wyeth versus Levine, 2009. Okay, now, what do you do here? You have Bates going one way, Regal going the other. The heads are spinning. And this case had to do with drug risks and failure to warn. And the manufacturer claimed that they could not add warnings above federal requirements. Again, you had partially preemptive language, and again, you had a savings clause. And how would this be resolved? And this time it's Justice Stevens again. And this case cites to both and discusses both Regal and Bates. but starts again with the presumption of preemption that was not used in the previous case, but talked about this as a federalism issue, about the importance of respecting state historic police powers and protective goals in the law. And in particular, the case very closely goes into the statutory language as well as what Congress did and didn't do, paid attention to the fact that if people were left injured without a common law remedy, there was no substitute remedy on the federal law, and the end reached a anti-preemptive outcome. One additional wrinkle, the court also kind of looked at the policy impacts. But instead of talking about, say, juries and the rest and just kind of asserting issues of unreliable juries, what the court did is it actually looked at a series of studies of the FDA's actual performance in the field and dropped a note saying, is there a need for common law? And the answer was there's evidence that there is. Several studies have said so. Now, let me jump forward. So what do I see in these cases? So kind of distilling them, what are the moves and counter moves? First, very importantly, for those who follow this area and those who are perhaps new to it, Congress, when you actually look at what Congress does, it is extraordinarily rare, thank you, extraordinarily rare that laws are fully preemptive. In fact, there are only a couple, 2 or 3 laws that, according to their express language, fully preempt common law regimes, that is, mentioning common law and saying so, and they usually have a substitute compensatory regime of some kind. What you actually see in laws is usually some preemption for kind of actual clashes and savings clauses that actually do preserve common law, that either mention common law expressly or talk about not prohibiting other protections or additional protections under state law, meaning federal law acts as a floor, a minimal level of protection, and states through common law or non-clashing state law can do more. So what you have is the political choice, the prevalent political choice in Congress is concurrent and overlapping regulatory power, kind of state regulation, federal regulation, and the possibility of common law inducements, meaning state law. Agencies historically have been fairly strongly embracing of ongoing viability of common law, but as previous panelists mentioned, during the Bush administration, there was a more pro-preemption push by an array of federal agencies. So there it's a bit more mixed. The courts really here in this area are, as I just perhaps demonstrated with 3 cases, are engaged in a sort of vacillating or seesawing sort of jurisprudence where it's more akin to kind of teams on either side that just won't take off their uniforms and they just take the next cut at the next opportunity, and they see if they can distinguish a case or some fact or some language to maybe get a majority. So they're characterized by 5-4 votes, typically, not always, but with closely divided outcomes. So, as far as activism and restraint, I think one issue people should think about is, what do we make of areas where courts, especially justices, just won't really deal with each other's precedents as anything more than an inconvenience, which is what I think we see in this area. As far as the technique and the preemption arguments, the anti-preemption block, which Justice Stevens was probably the most frequent writer on behalf of, actually pays very close attention to statutory language. It looks at savings clauses. It tends to work with the different cases. It does notice historical context, and it also tends to embrace the instrumental aims of the protection of tort law. The pro-preemption block really emphasizes obstacle preemption. They don't like the way laws can strike different balances. And there are certain words, in addition to crazy quilt, the kind of telltale words to work for are patchworks. Patchworks are bad, crazy quilts are bad, inconsistent juries are bad. The Chamber of Commerce in some recent briefs had my favorite new phrase, which is push me, pull you, which is, I think, a Dr. Dolittle reference. I don't know. Could someone look that up? Which is the push me, pull you of different state and local mandates. And then there's also a strain which is very prevalent, which is really quite explicitly distrusting of the jury system. So what do we make of this? I said I wanted to close with this 2 closing thoughts. What? Is there a way to make sense of the kind of relative legitimacy or approach of this different architecture and these different approaches? And actually, I would say there is. I mean, on the 2 sides in this area, I think in the kind of anti-preemption block, maybe it's the outcome they like, so they come up with a technique. I guess you can always say it's ends-oriented judicial decision-making. But if you actually look for kind of fair attention to statutory language and grappling with precedents and looking for, say, agencies to exercise expertise versus just declare outcomes, the anti-preemption block tends to be fairly kind of looking at all the data points and reaching an outcome. The more pro-preemption block, it's quite striking when, for example, when Justice Scalia in the Regal case talks about juries and 50, the risks of crazy, he doesn't say crazy quilts, of different outcomes. There's no citation to anything, okay? Now, judges can take judicial notice of things like water, ground gets wet when it rains and things like that. But to make bald assertions about juries and their unreliability and the incentives and harms of common law with citation to absolutely nothing whatsoever, I think is a kind of a telltale sign of judicial policymaking. Also, for both sides, the failure to do precedent is an issue. Just lastly, in this, one kind of, I think, problem in this area, as a group of, I think, people in this panel, as well as my colleagues Bobby Ade and Robert Shapiro, have been working on and writing about, and other people around the country, Kirsten Engel and a group of other scholars, people have been looking at issues of federalism, and I think there are some kind of neglected norms and instrumental values that should be paid more attention to, okay? And so while people talk about the laboratories of democracy and the benefits of having many states and many political actors addressing complicated regulatory risks, I do think that there is, in the preemption area, especially in judicial jurisprudence, failure to respect the benefits of ongoing conversation about difficult regulatory challenges. That there really is, what some may see as a crazy quilt can actually be a fruitful interaction where jurisdictions learn from each other. And in addition, so this kind of interjurisdictional dialogue or learning. And then, in addition, something that Tom McGarity, a professor at Texas, has written a lot about common law and regulatory exchanges. He makes a very nice point, which is worth emphasizing, and that is when you're thinking about preemption arena, and he talks about this in both this book that I helped edit and his book, which is a superb book called Preemption War, that common law regimes tend to elicit information that is often plowed back into the regulatory process, and similarly, the regulatory process tends to elicit information that then is used in the common law process. And one of his points is we shouldn't forget that there's a sort of feedback loop between common law regimes and regulatory regimes, and to the extent preemption policy ends up broadly displacing or preempting one actor or the other, usually meaning common law, you can lose the benefits of this fruitful dialogue. So I'll sit down and allow time for some questions. Thank you.
So I want to invite folks to step up to the microphones for questions. I want to quickly see if any of the panelists have questions or follow up to one another's remarks. I have a question, but I'll see where we go. But I don't know if any of you have to begin sort of anything to corrections, amendments. Please.
Well, it's interesting that this session on federal and state politics and federal judging and state politics and so on did not mention, I won't say the elephant, but the Tyrannosaurus Rex in the room, which of course is Bush v. Gore. Bush v. Gore was the Supreme Court against the Supreme Court of Florida, and very explicitly so. And the account that was given about the Supreme Court's back and forth with the Supreme Court of Oregon was very reminiscent of what happened between the Supreme Court and the Supreme Court of Florida. What people tend not to mention about Bush v. Gore is that there was a previous decision of the Supreme Court which was unanimous and sent the case back to Florida with certain instructions. And the Florida Supreme Court, Oregon-like, completely disregarded them. And there's one thing that I would have thought really annoys the Supreme Court is when somebody disses them. And they were so annoyed that we got 8 years of George Bush. It's really quite remarkable. And I'm only surprised that the Supreme Court in The Oregon situation was not similarly irked by the obvious finger that the Oregon Supreme Court was giving them, because that's what was happening. It's very remarkable. So that's politics back and forth. There's one aspect of politics that wasn't mentioned, that what we're talking about almost invariably is appointed judges, federal judges, against elected judges, because state court judges are, in one way or another, elected judges. And if you don't think that the way state court judges decide tort issues has some effect on their election, I've got some real estate I'd like to sell you.
So first on Bush v. Gore, of course, my response would be so intricate that I couldn't extemporaneously anything. As for the Oregon State Supreme Court, there is a fuller story. I think it's interesting. We never know when the U.S. Supreme Court takes a case and then digs it why. I think a few insights can be gleaned, though. One is that the court clearly had an opportunity. Philip Morris had asked them. Judge Roberts, even during oral argument, reminds the court clearly, if they didn't want to deal for whatever reason with the procedural due process, could have taken that case on substantive due process grounds, that it's just too large, and they didn't. And I think that's actually an important insight that's been missed in a lot of the commentary in punitive damages, et cetera, that this court, while it's somewhat aggressive about its desire to rein in punitive damages, is skittish about taking the substantive due process route. I've also written about in Exxon Valdez, right? The court in that case, that was the oil spill case where the jury had given $5 billion in punitive damages. The court also could have done a substantive due process constitutional review of that verdict. Instead, they took up only admiralty law questions, and the court decided under federal admiralty what to do, and they drastically reduced the punitives to a 1-to-1 ratio. I think what the court was trying to do is say, boy, we really want these punitives to get reined in. We don't want to do it through substantive due process. We'll do something quite unusual and sit as a common law court and provide a template. So therefore, courts, you should follow us by doing this. So I really do think there are limits to what they can do when they think someone's thumbing the nose at them. The other thing I'll say, though, is, and this is more speculative, if you read the transcript of the oral argument from the second Williams case, there's a really interesting moment where Judge Roberts uses the word malodorous. I guess that's the mellifluous way of saying they're thumbing their nose at us, they're dissing us. And Justice Stevenson, I think somewhat strategically, gets Philip Morris's lawyer to concede on the record, says, do you think that the Oregon State Supreme Court was acting in bad faith? And he says, no, and we don't allege that. And I think that was really an important pivotal moment, because if they don't think the court's actually acting in bad faith, it becomes really hard to sort of parse that distinction. Your second point about elections, I just neglected to mention. That's, of course, why I could even pit my remarks about what state court versus federal courts are doing in the preemption realm as any kind of collision. It's precisely because the state court judges are elected, and that's the political sort of element or state politics that comes into play versus the federal. But thank you for bringing that to the fore.
Who's on that question? Actually, maybe I'll chime in, and if other questions come up, because my question very much related to Charles's. I was interested if any of you have any thoughts on what we should think of as the meta game that's going on between federal, let's call it first federal institutions and state-level institutions in the settings you're talking about. But obviously, federal and state courts is a very natural nexus, since we've talked about some examples of that. And I'm wondering, sort of, one could plausibly think of it as conflictual or as a clash, but one could plausibly think of it as cooperative or at least coordinative in some fashion. And here are two references that come to mind. One is an article I'm sure many of you know and many of you may know by Robert Cover and Alex Alenikoff of now some 30 years ago, Dialectical Federalism. They wrote about the idea in the habeas context of a kind of a coordinative interaction that takes place between federal and state courts where neither can, in essence, fully assert their will and as a result have to sort of engage the other. The other reference is Joseph Weiler and Karen Alter and some others in the European context have talked about the interaction between, interestingly, lower national courts and the European Court of Justice, and the way in which lower national courts have, in essence, used the European Court of Justice as to gain leverage against their own national courts. So I wonder whether, what you think of, again, we should perceive as the meta game that's going on between federal and state courts in some of these settings, including, I thought of in the California context, right? Because there's the preceding California decision that Proposition 8 is undoing.
Right. I mean, I think in when you're talking about gay rights litigation, the story of the conversation between state courts and federal courts has been one that's been going on at least since the 1980s. So in the wake of Bowers versus Hardwick, the U.S. Supreme Court decision upholding Georgia's sodomy law, state courts began to weigh in on their own sodomy laws. And I think maybe 8 states invalidated their sodomy laws through state Supreme Court decisions, and were commenting on the same constitutional norms that the Supreme Court had commented on. In fact, citing Justice Blackmun's dissent as more persuasive to them in interpreting their own state constitution. And so they weren't just interpreting their own state constitutions, they were interpreting American constitutional norms. And so when Lawrence gets to the court, Justice Kennedy is able to cite the emerging awareness and the criticism of Bowers, including citing Professor Freed and others from the scholarly community that had criticized the underpinnings of the decision, and citing the state court decisions that had taken issue with the reasoning. And so I think in some ways similar conversations are happening around marriage, where the big movers were state Supreme Courts, partly, I would argue, because state Supreme Courts had weighed in post-Bowers versus Hardwick and started to build pro-gay law on which they can later base other decisions. And now the federal courts are starting to weigh in. The difference between the Prop 8 federal litigation, which is, when framed from the get-go, a very sweeping challenge about fundamental right to marry for same-sex couples and the suspect classification status of sexual orientation, is different than what we see coming out of Connecticut, New York, Massachusetts, where gay rights litigators have challenged DOMA as applied to married same-sex couples in Connecticut, Massachusetts, in states where they are recognized as married, which to me suggests a more nuanced understanding of the interaction between the federal and state courts than the Prop 8 litigation does.
The only thing I would say is that I think that your examples are a great one of people strategically trying to figure out the venues in which to illuminate issues. So essentially the progress is made over time without a sudden rejection. So I think when people talk about the benefits of courts battling with courts, there's also just the issue of how courts can inform the political process and perhaps public national debates, which is itself a value of the legal system. And I think that's slightly different than courts just battling. It's actually just informing the public. But I think there are a few people, so we probably should.
Please.
This question is for the panelists who spoke about preemption, and Bill, in particular, you spoke about some of the recent preemption cases. What do you think are some of the preemption issues that may be coming down the road in the next few years?
I think the court, even the justices who purport to care deeply about the plain language of a statute, the Supreme Court has made clear that a savings clause in a statute that is one that says Congress is setting up this regulatory regime and then says standards issued pursuant to the statute will have no effect on common law. There's a few statutes that have very explicit savings clauses, and the Supreme Court has said that those have no meaning, essentially. There are a few statutes, including the recently enacted Dodd-Frank Wall Street Reform Bill, that have provisions that say that there's no implied preemption, or there's no preemption beyond the scope of this the express preemption in the statute. So it isn't explicitly directed at saving common law, but it's explicitly directed at not allowing this sort of nebulous obstacle preemption. Because it's in a couple recent statutes as well as a couple older ones, I think that whether Congress has the power to disavow any implied preemptive effect is an interesting and unresolved question. There's also, the justices have been quite inconsistent in the weight they give to the federal the views of the federal government. Breyer's statements about it are incredibly consistent, except that in Wyeth he went against them. But I think it's hard to have a principled doctrine when the justices can't even figure out what the role is for this. Is it incredibly important? Is it a little important? Is it not important at all? And they're all over the place. And it may be that there's some room to resolve that question. I'm not sure they're up to it. I think Bill suggested that perhaps they're not.
I would just say three things I see happening. One is, none of us mentioned actually in the recent Wyeth case, the last of the trio that I talked about, Justice Thomas writes a long opinion saying he thinks the entire implied obstacle preemption is a problem, that it unleashes judicial activism, or I think he says it's unrestrained. I can't remember the exact word. I'm not sure he uses the word activism. But, and so he had been voting previously in the often pro-preemption block in close cases. So one question now is he going to consistently now disavow relying on implied or obstacle preemption in future cases? And if so, then that will change the path of the law. There's a pending case that Allison wrote a couple briefs on, the Williamson-Mazda case, where the Chamber of Commerce's approach is interesting. It writes an argument saying, uphold this previous case called Geyer. Don't throw out this long, historically important concept of implied obstacle preemption. It goes back to our very founding, and it doesn't go back to Shakespeare or the King James Bible, but more or less the argument is historically that this is important. And so, so I think obstacle preemption is itself kind of in play. Second, I think one implicit trend that we're seeing in the cases is that I think at least several members of the court look to see if agencies want to assert a pro-preemption position, are they basing it just on flat-out declaration, or are they actually doing kind of the work? Are they looking at the underlying facts and actually establishing the need for a preemptive outcome? And some area that I've written about, and Kathy, is the idea that there should be something akin to what we call hard look review for pro-preemption assertions. Well, I'll stop there. I go more, but Kathy, I'll let you.
Yeah, I just want to, I think, make two comments. And I think I disagree. So one is, and I held off because there were questions in the audience, but when Bill talked about Regal and used that as the exemplar of Scalia just coming in with his own view of what requirements is, and he hates juries, Regal was an 8-1 decision of the U.S. Supreme Court. So Justice Ginsburg dissented. But it's fascinating to me because while people try to put a kind of political valence on these kinds of cases, that one, it might be surprising. How did all these other anti-preemption people sign on to that? I think that that's just kind of an important fact about Regal. In terms of trends, one, I think we're going to see a lot of distinctions being made between the express preemption realm versus implied. And this is a court, I think, that has been quite expansive in reading express preemption very, very broadly while narrowing implied preemption, including Justice Thomas. And one other just fact, his lone concurrence in Wyeth, where he wants to trash implied preemption, is joined by no one. I think that's very telling. I don't think we're going to see, many people are commenting that in a case pending before the U.S. Supreme Court right now, Williamson versus Mazda, which is a revisiting of Geyer, the seminal implied preemption, we may see the death of implied preemption. I'll sell some real estate to those folks as well. I don't know where they're getting that. Justice Thomas stood alone and made his impassioned plea, and no one joined him. But I do think this is a court where we're going to see, and I think people forget express preemption is really an important area. So if Congress has said anything and hasn't even been clear, if the court pushes that really broadly, and they're going to be preempting not just state tort law, but state regulations, et cetera. It's a really big area. And then the second bill sounded this role of the federal agency. I guess I would just push it a little further because, as I said, I think that's the meta of what's going on in these cases. I think you can tell a pretty consistent story about the outcomes in these preemption cases, even Wyeth versus Levine, where the FDA argued vociferously for preemption, but the court didn't go there. It's because they looked at how the procedural irregularities, the lack of care, actually there was some stealth maneuvering by the FDA, where the FDA in its rulemaking said, we will not be preempting, and then in the final rule came back and preempted. So the court, I think, is interrogating. They're not just blindly following whatever the agency says, but I think that's a really pivotal factor. I think it's going to be pivotal in the two cases that I'm looking at, the Williamson case, where the NHTSA is arguing against preemption and is providing some of their record evidence there, and also the vaccine preemption case. There was a pivotal moment where CDC started talking about what they do with respect to regulating the risks. And the takeaway point from that, I think, actually is for litigants and certainly for groups that represent quote-unquote state rights, is I think it's foolhardy to be focusing all of your attention on Congress. I think you should be looking at the rulemaking process. You should be looking at who intervenes in that process, who makes the agencies stand accountable for the views, et cetera. So that's where I think the terrain is shifting.
Can I mention one other
Please.
case? There's another extremely important preemption case in front of the Supreme Court, the AT&T versus Concepcion, and the question is whether the Federal Arbitration Act impliedly preempts state contract law. And the reason it's so important is because every single one of us is subject to mandatory arbitration provisions in most every our cell phone agreements, pretty much anything, any consumer agreement you sign on to these days. A lot of these agreements lately have class action bans in them, so you have to arbitrate, and you can't arbitrate as a class action, and you can't litigate. So the question is, and California in this case, and a bunch of other courts in other cases, found that such class action bans were unconscionable under state contract law. We assumed the Supreme Court took that case, there was no conflict among the circuits, just to completely screw the consumer side. But the argument didn't really go that way. We're guardedly optimistic. And one thing that was interesting that why I brought this up is because Justice Scalia seemed very concerned that AT&T was asking him to tell California how it should apply its contract law. He doesn't express any such concerns about how California or New York or Georgia should apply its tort law, but he said quite directly to the guy arguing, but California says this is its unconscionability law. So we may also be seeing some difference in approach by the justices depending on sort of what state law is being potentially ousted.
Wonderful. Well, we're out of time. Please join me in thanking our panelists for another great session.